In this lesson, we're going to move on to looking at the next limb of the negligence equation. We're going to focus on the question of breach of a duty of care. Now, this is going to occupy us for sort of 3 or 4 videos. We're going to talk about the standard of care. We're going to talk about shifts in that standard of care. We'll talk about the idea of magnitude of risk in certain circumstances. But for now, I want to just spend some time thinking about the idea of a breach of a duty of care. Let's assume, for the time being, that the previous few lessons that we've looked at, we have established that there does indeed exist a duty of care, whether it's novel or whether we can draw analogies to previous cases. Well, the next question then is whether or not we can say that that duty of care has been breached. Now, once a court has decided that there exists a duty of care, the next question is whether or not the defendant has breached that duty. Now, in this case, a breach of a duty of care is where basically there is a failure to act in a certain circumstance to a certain level, let's say, to a certain standard, we might say. It is determined by a standard of care. And so when we think about breach of duty of care, basically once a breach has been established, think of the standard of care as a sort of line, a line that any reasonable person would be above in terms of their actions in that circumstance. If you fall below that line, if you are so inadequate in your acts or your omissions that you fall below a standard, a basic standard of care, then you are said to have breached your duty of care. That's essentially how we think about it. And so fundamentally, what that standard is a really important question then. Because essentially, by determining what the standard is, determining whether or not the defendant has fallen below said standard, can then determine whether or not there has been a breach of duty. And if we can do that, we can then tick that off and move on to the next stage, which is, of course, looking at causation. So the courts are required to essentially ask 2 questions when we are thinking about breaching a duty of care in these kinds of cases. The first question is, what standard of care does the law require? This is a basic question that is a legal question, fundamentally. The legal question, which we'll get to in a second, and we'll think about what that standard generally is. But then the next question is a factual question and is decided on by thinking about the facts of a particular case, i.e., did the defendant fall below that standard of care? So we have a standard that is established by the courts, and now we are going to apply the facts to the law. We're going to apply the facts to this particular standard and go, well, did they actually sit above that standard of care, or did they fall below it? If the answer is yes, they sat above that standard of care, or they sat along the line of the standard of care, let's say, then there is no breach, there is no claim. If they fell below it, then there is breach. There might not necessarily be a claim, because then you now have to move on to the next question, which is thinking about causation. So the standard of care then is very important, and it's an objective standard, okay? And the objective standard is the following. What would a reasonable person do in the defendant's situation? Very, very simple. We're bringing back into the fold this question of a reasonable person. What would hypothetically a reasonable person of basic temperament, which we'll get to this in a second, of honest belief and honest best judgment, what would they do? How would they have performed their duties in that particular circumstance? And if it is the case that the defendant in the particular instance that we're thinking about acted basically the same as the reasonable person would have acted, then that means that there is not a failure, there is not a breach of duty, they did not fall below the standard of care. If they didn't, if they fell below that, if a reasonable person, a hypothetically reasonable person, was to perform something that would have been above what the defendant in fact actually did, well, then they have breached their duty because they've fallen below the standard of care. Now, it should just be noted, if it's not already obvious, that the reasonable person in this circumstance, the man on the back of the Clapham omnibus, is not a real person. It's a sort of hypothetical person that we can sort of impose into the situation. We sort of insert them into the factual circumstance of a case. and we sort of see what they do. We sort of simulate like a computer simulation. What would this reasonable person do in this circumstance? And we think about, well, a reasonable person would probably have done this in this circumstance. If that is the case, and the person who is actually in the litigation, the actual defendant, didn't do that, then they are not acting in a way that a reasonable person would have acted, and they are falling below a standard. The idea of the reasonable person test was developed firstly in the case of Vaughan and Menlove from 1837. So it's an old case, and it's an old principle. In this case, the defendants had built a haystack next to the claimant's cottages. He had been warned repeatedly by the claimants that this stack of hay was dangerous, but ignored those warnings. Dangerous because it can catch fire. Dry hay is it's very easy to catch fire. All you need is a bit of mechanical equipment, all you need is a certain hot day, and lo and behold, there you go. If it's a dry, hot day, blows up into fire. And this is exactly what happened. It caught fire, and that causes damages to the claimant's properties, the claimant's cottages. And the courts established the reasonable person standard in this case. They established a principle that was that a defendant must act with reasonable caution as a prudent man would have exercised under the circumstances. Honest belief or subjective best judgment is not enough, because what counts as honest belief or subjective best judgment is a very, as the name suggests, subjective. It's a very broad standard. A subjective best judgment of one person might be far, far, far below what the rest of society actually deems to be best judgment in that particular circumstance. And so what matters is whether or not an ordinary person of ordinary prudence, of ordinary skill, and of ordinary state of mind would have done in that circumstance. What would they have done in that circumstance? Now, it should be noted that there are cases in which the reasonable person test is adjusted, okay? And I'm going to get to that in future lessons' time, in the next video specifically. There are certain circumstances in which a reasonable person is not best equipped, shall we say, best suited to establish a standard of care. So in very professional circumstances, for example, like a medical professional, they wouldn't apply the standard of a non-medical professional. There are certain changes that take place when we think about children and how that applies to a standard of care. All of that in future videos' time.